Picture this. A cornerstone of America's fight for racial equality in voting rights is teetering on the edge, potentially facing dismantlement at the hands of the highest court in the land. That's the dramatic scenario unfolding as the conservative-leaning Supreme Court prepares to tackle a high-stakes congressional redistricting dispute from Louisiana, where the future of a vital section of the landmark Voting Rights Act hangs in the balance. But here's where it gets controversial. The justices are probing whether states can ever factor in race when sketching out new electoral boundaries, all while trying to align with Section 2 of the 1965 Voting Rights Act, a law born out of America's dark history of racial discrimination to shield minority voters from being sidelined. To help newcomers grasp this, let's break it down simply. Redistricting is the process where states redraw the lines of congressional districts every decade after the census to ensure fair representation. In Louisiana, this became a flashpoint because the original map only featured one district where Black residents formed the majority, despite African Americans making up about a third of the state's population. Civil rights advocates sued, arguing this violated the Voting Rights Act, prompting the state to rework the map into one with two majority Black districts. For beginners, think of it like this. Majority Black districts help ensure that Black voices aren't diluted in a sea of other voters, giving them a stronger shot at electing representatives who reflect their community's needs, a key way the act combats historic disenfranchisement. The Supreme Court first delved into this case earlier this year with a narrower focus. But in a surprising twist over the summer, they expanded it dramatically, urging both sides to argue a bigger, more sweeping constitutional question. And this is the part most people miss. Now, the justices are weighing if creating districts with a majority Black composition breaches the 14th and 15th Amendments. Those post-Civil War additions to the Constitution designed to guarantee equal rights for formerly enslaved people, including the fundamental right to vote without racial barriers. Conservatives in the courtroom and beyond are pushing a strict, color-blind view of the Constitution, claiming that any nod to race in districting, even to rectify past injustices, is forbidden. This echoes the court's recent 2023 decision that banned race-based considerations in college admissions, emphasizing a vision where the law treats everyone identically, regardless of skin color. It's a stance Louisiana initially resisted, but they've since flipped, teaming up with a coalition of self-described non-African American voters suing to overturn the new map on these very grounds. Even the Trump administration has thrown its weight behind this shift, amplifying calls for a race-neutral approach. On the opposing side, civil rights organizations that triggered the original lawsuit are staunchly defending the revised map, stressing that without it, minority voices could be drowned out once again. The Voting Rights Act, a bulwark against voter suppression tactics, has faced relentless conservative challenges, with the court chipping away at it through major rulings in 2013 and 2021. Yet, just 2 years ago, in a different redistricting battle from Alabama, the court unexpectedly upheld the act's core tenet that race must sometimes be factored in to redraw districts and meet its mandates. That 5-4 verdict saw Chief Justice John Roberts and Justice Brett Kavanaugh, both conservatives, side with the liberals, though Kavanaugh hinted at doubts about Section 2's longevity. If the court rules broadly in Louisiana's favor, it could slash the requirement for states to create districts predominantly made up of minority groups, likely shrinking the ranks of minority lawmakers in Congress and state houses nationwide. As an example, imagine states like Texas or Georgia, where diverse populations might see their political influence wane, potentially leading to fewer representatives who prioritize issues like economic equity or criminal justice reform in communities of color. A swift decision could even allow Louisiana and similar states to redraw maps in time for the 2026 midterm elections. And with Black voters tending to lean Democratic, such changes might tilt the scales toward Republicans in those races. This isn't just legal jargon. It's a debate that cuts to the heart of American democracy. Does striving for racial fairness in voting maps undermine the ideal of equality? Or is it essential to heal centuries-old wounds? And here's the real hook for differing opinions. Some argue that a colorblind constitution is the purest path to justice, preventing any form of racial favoritism, while others contend it ignores the reality of systemic disadvantages that still plague minority communities today. What side are you on? Do you believe the Voting Rights Act should evolve to eliminate race as a factor altogether? Or does protecting minority representation trump strict neutrality? Share your thoughts in the comments. Let's spark a conversation on this pivotal moment in civil rights history. By Lawrence Hurley, Senior Supreme Court Reporter for NBC News.